Dear learners, yesterday I was speaking on the topic of gift and discussed various aspects of this topic, that is of the gift under Muslim law or Hiba. And in last I made the point that in order to make the gift complete and valid, it is necessary, rather it is must, that donor should hand over or deliver the possession of the subject matter of the gift. Until there is effective delivery of the possession of the subject matter of the gift, under Muslim law, gift is neither complete nor becomes valid. Therefore, having regard to the nature of the property, it is indispensable that property should be handed over, or subject matter of the gift should be handed over by the donor to the donee in such a way that donee is in the actual or constructive possession of the property, and being in the possession of the property, he is also in a position to derive all the benefits from the subject matter of the gift as it was being derived by the owner or donor immediately before the delivery of the possession of the subject of the gift. It has been held by the court in successive judgments that unless and until there is effective delivery of the subject matter of the gift, it is neither final nor the complete. It is only on the delivery of the possession of the subject matter of the gift that gift under Muslim law becomes final, complete and valid. Therefore, where a person made the gift of his property, made a valid declaration, and followed by there was also acceptance of the gift by or on behalf of the donee, but donor did or there was no evidence of showing that donor ever handed over the possession of the property, or donee was put into the actual or constructive possession of the property of the gift. Gift is never complete and never valid. But once there is a delivery of the possession, so as soon as the donee gets into the actual or physical possession of the property, he becomes the owner thereof. Gift is complete, and as soon as he takes over the possession of the property, at the same time all the proprietary rights of the donor, they pass out of his control and they vest in the donee, and donee become a real owner of such property which has been gifted or donated to him by the donor. Ladies and gentlemen, this is the general principle, or this is the general rule of the gift under Muslim law. Whereas immediate delivery of the possession of the subject matter of the gift is not necessary under the Transfer of Property Act. Delivery may be given later on at some stage. What is there necessary? That there must be some evidence of showing that donor has transferred the ownership in a specific property in the name of the donee. So, simply the evidence of showing the transfer of the ownership in respect of the property in question will be sufficient to show that there has been a valid and complete gift or possession. But under Muslim law, the evidence of transferring the ownership is not necessary. What is essential, what is indispensable, that there must be evidence of showing that the property itself has gone into the control and possession of the donee immediately after the declaration and acceptance of the gift. If the donee has not taken over the property, gift is not complete and he will not be, because without the possession, the donee will not be in a position to take the advantages or to enjoy the fruits or the usufruct flowing from the corpus of the property, which is the subject matter of the gift. Therefore, in order to facilitate the proper enjoyment of the subject matter of the gift by the donee, it is necessary according to the Muslim law that donee must come into the actual or constructive possession of the property which has been donated or gifted by the donor to him. Simply the passing on of the rights will not be sufficient, because simply say for example, if somebody has registered and there is a evidence that the gift has been registered, so registration itself is not going to enable the donee to take the advantage of the property which has been registered in his name. What is necessary, that the property in actual form or in actuality should go under the control and possession of the donee. Only then he will be in a position to exercise to take the advantages flowing from the, say for example, if somebody makes the gift of a house exists in a physical form. Only the document showing that the house has been registered as gift in the name of the donee X, according to the Muslim law, this will not be sufficient. What is necessary, that donee should be put in actual possession of the property, that is the house, and donor should have withdrawn himself actually from the possession of the house in question. Means donor should divest himself of all the rights as well as the control over the property, and same must be allowed to be vested in the donee. Only then the gift will be complete under the Muslim law, otherwise gift will not be. Ladies and gentlemen, this is the general principle of Muslim law, this is the third essential of a valid gift under Muslim law, that is delivery of the subject matter of the gift by the donor to the donee. How it will be ensured that there was delivery of the possession of the property by the donor to the donee? It will depend upon the nature of the property as well as and the circumstances where in the property is situated. I have already given the example. Say for example, it is the house. Then a donor first of all should withdraw himself, and vacant possession of the house should be handed over to the donee. Means key of lock should be given to the donee, and donee should enter into the possession of the house, and when he start living into the house or enjoying the benefits of the house as it was being enjoyed immediately before the delivery of possession by the donor, then it will amount that there is actual delivery of the possession of the subject matter of the gift by the donor to the donee. For example, there is a same example. If there is a gift of the house, but the gift at the time of donation was on rent, and there was tenant. Tenant was then in that very case withdrawal of the tenant is not necessary. What is necessary? That steps should be taken by the donor in such a way that donee has become in a position, has come into the position of the donor, and as the donor was receiving the rent from the donee, from the tenant, in the same way henceforth that donee will be should be made entitled to receive the rent etc. from the house. If this type of the evidence is shown, will be deemed that the donee has been put into the constructive possession. This will be the constructive possession of the subject matter of the gift, and gift will be regarded as valid and complete. Ladies and gentlemen, uh, against this general rule, there are few exceptions. Uh, there are three exceptions to the rule that in order to complete and valid the offer and acceptance must be followed by the immediate delivery of the possession of the property, that is the physical departure of the donor and formal entry of the donee. These exceptional situations are that where gift is by the husband to the wife or vice versa. Friends, where rule is that where donor is husband and donee is the wife of the husband, or vice versa, wife is the donor and her husband is the donee in a given case. Now, in such circumstance, this formality of handing over the possession by the donor to the donee is not necessary. It is dispensed with and it is relaxed. Our reason is that where such type of the situation is, then normally in such situation both the husband and wife are supposed to be living in the house, and since they are both are supposed to be living in the house, therefore it is not necessary that the husband should go out of the house along with his belongings, and then wife should be allowed to enter therein, and then again the husband being the partner of the wife should again come back along with his belongings or luggage or items, and again he should should come in the house and start living. So this on the face of the record appears to be unnecessary formality uh, uh, in order to and therefore in such situation rule has been relaxed that since before the gift husband and wife were putting up in the same house, one fine morning out of the love and affection, husband makes a gift of his house wherein both were living in the name of the wife. Then wife, the law does not require that husband should go first of all out of the uh, premises of the house along with his items, luggage or belongings, and then wife should come and take over the possession, and then again the husband may come because they are the partner and they are supposed to cohabit with each other, and for cohabitation with each other they should live under the one roof. So this type of the necessary formality appears to be unnecessary and superficial, and therefore Muslim law has relaxed the rule in this situation that delivery of the possession will not be necessary. But remember that this rule will be applicable only where at the time of the gift husband the relationship of the husband and wife subsist and continue. If before making the gift there was a legal separation between husband and wife by means of the divorce or talaq, and talaq has become the final, and thereafter the husband makes the gift of his certain property in the name of his former wife, then in that case the delivery of the possession of the subject matter of the gift by the donor to the donee will be must, and a donee will. In the same way, if there is simply separation and not dissolution, there is only separation of one partner from the other on certain grounds, but there is no final dissolution of the marriage. So, in that very case also, uh, delivery of the possession will not be necessary. But if by decree of judicial divorce, parties have been separated from each other, their bond of the marriage has come to end, then in that very situation it will be necessary. So, to apply the rule in case of the husband and wife, it is necessary that this type of the relations should subsist and exist at the time of making the gift. So, this is one of the situation where under the husband is the rule that possession, delivery of the possession is must, is relaxed, and it is not necessary that there should be such type of. Likewise, where the gift is by the father to the minor, because already I have explained that in case of the gift, if the minor is underage, then the delivery of the possession of the property should be handed over by the donor to the guardian of the father, or any other legal guardian in the absence of the father. So, basically, uh, where a gift is by the father to the minor child, and child is incapable to hold the property, is incapable to take the possession of the property, then in such circumstance, uh, property basically is required to be given to the legal guardian. But if the father is the donor and donee is his child, then since the father himself is the lawful guardian of the property of the minor, and therefore he himself is required by law to take over the possession, so this will also be unnecessary formality, and therefore in such situation where donor is father and donee is minor son or daughter of the donee or donee, so in that very case simply declaration of the gift, acceptance of the gift are sufficient. A delivery of the possession is not necessary. Even without delivery of the possession, the gift shall be deemed to be complete and valid under the Muslim law, and donee will become the owner thereof immediately on the acceptance of the gift by the donee. Where the donor and donee resides in the same property which is subject matter of the gift. Of course, on the face of the record, it appears that this formality is unnecessary. Therefore, even in this situation, this gift, this delivery of the possession is not necessary at all. There are so many cases on the point decided by the court. In Fatima Bibi vs. Abdul Rahman 2001, the husband made an oral gift of a house to his wife. On the challenge to the validity, the trial court held that the gift fulfilled only one condition, that is the declaration, and rest of the two conditions, acceptance and delivery of the possession, were not present. The gift was invalid. The matter went in appeal, and court held that in case of the gift by the husband to his wife of the house that they were occupying, there is constructive delivery of the possession. So, this is the situation very clear, and there are some other cases also wherein this is the rule that first of all the possession should be handed over to the women. In case there is no one, then it can be given to other person, that is to the. So, gift by the husband to the wife, in this case delivery of the possession is not necessary. Where gift is by father to the minor child or by the guardian to the minor child, again delivery of the possession is not necessary. and even without delivery of the possession of the subject matter of the gift, gift will be complete and it will be final. Here friends, this is the very classic case, Musa Miya versus Qadar Waqs, wherein a grandfather made a declaration declaring the donation of certain part of his property in the name of his minor grandson. Declaration was made by the grandfather in the presence of the father of the donee that he is donating such and such property to my grandchild, who will be the donee in this case. Declaration was made, acceptance was also given on behalf of the donee by the father, that is the who was the lawful guardian of the property of the minor. Then later on it was challenged, and it was held that where the gift is by the donor in the name of any minor donee, then law requires that acceptance in such cases should proceed not from anyone but should proceed from the father only if he is alive. If he is not alive, and then the next person is his executor. If none is available, then the gift can be made here. If there is no one, this father should accept the gift, or acceptance should proceed from the father. In the absence of the father, it should proceed from the grandfather. Here in this case, in Musa Miya case, acceptance was given not by the father but by the mother herself. Therefore, the court held that when the father himself was available for giving the consent or acceptance, why did he not give? Why it was given by the mother, and therefore this gift was held not valid. Gift by minor to minor by minor, gift to a minor by a person other than the father or guardian. I have already explained the point. Where donor and donee live together in the same house or in the same property that is subject of the gift, in that very case also the delivery of the possession is dispensable. Now friends, this is all about the situation or cases wherein the delivery of the subject matter of the gift is dispensable or is relaxed, can be relaxed, and even without delivery of the possession, if other proof are established, then it will be deemed as if there was a valid gift. And now I proceed to discuss revocation of the gift. At the outset, I would like to clarify that under Muslim law, all the transactions involving the transfer of property are revocable and can be revoked subsequently. For example, in case of wasiyat or will, there is a transfer of the property or ownership which is to take effect after the death of the testator. But whosoever is testator in a given circumstance or in a given case, it is within the power of the testator to revoke or cancel the gift at any point of the time before the death. Means before the death, the will is revocable and could be revoked by the testator. Likewise, in case of the gift under Muslim law, gift is also revocable and can be revoked by the donor himself. And in case of the gift, since gift becomes final and complete on the delivery of the possession of the subject matter of the gift by the donor to the donee, and until the delivery of the possession the gift is incomplete, therefore it is within the power of the donor to revoke it before making the actual or constructive delivery of the possession of the subject matter of the gift by the donor to the. Thus, if gift is revocable, thus the gift is revocable until the delivery of the possession. Where possession of the property is delivered, gift becomes complete and irrevocable. Thereafter, the question of revocation may not arise. However, therefore, the delivery is therefore the revocation of the gift can be discussed under two headings: before the delivery of the subject matter of the gift by the donor to the donee, and after the delivery of the possession of the subject matter of the gift by the donor to the donee. What are the possibilities of revocation before the delivery, and what are the possibilities of revocation after delivery of the possession? Before the delivery, a gift may be revoked by the donor at any time before the delivery of the possession, because delivery of the possession is basically essence of the completion of the gift. Therefore, where possession has not been handed over by the donor to the donee, then before handing over the possession, he at any point of the time he can revoke the gift or he can cancel the gift, and this will be a immediate revocation. The reason is that the gift is not gift before the delivery of the possession, and hence the rule relating to the gift do not apply over it. Very clear. In Bibi Riazan Khatun versus Sadrul Alam, 1996, Patna High Court held that revocation of the gift is permissible if the donor has not relinquished his control over the property and donee has not been put into the possession of the same or in the possession of the subject matter of the gift. Therefore, as a general principle, before the delivery of the subject matter of the gift by the donor to the donee, it is well within the power of the donor to revoke the gift, and if the revocation is made, it will be well and good and shall be deemed as if no gift was made by the donor in the name of the donee. After delivery, suppose there is a situation where under subject matter was handed over by the donor to the donee, and thereafter he is wishing to revoke the gift. So, what is the possibility here? When a gift is made and the subject matter of the gift is duly transferred to the possession of the donee, it is its revocation is not only possible, and its revocation may be possible only by the intervention of the court or by the consent of the donee. A mere declaration on the part of the donor is not enough. Try to understand that where there is simply declaration of the gift and acceptance of the gift, but there is no delivery of the possession. So, in between the acceptance and delivery, it is within the control of the donor to cancel the gift, can revoke the gift without any formality. Simply just by making another declaration, he will cancel the gift. But once the property has been handed over by the donor to the donee, then what are the possibilities? The rule is that when gift is made and the subject matter of the gift is duly transferred to the possession of the donee, its revocation is only possible by the intervention of the court of law or by consent of the donee. A mere declaration on the part of the donor is not enough. However, following completed gift cannot be revoked even with the consent of the donee or intervention of the court. Or what are those cases where it is made by the husband to his wife or vice versa? Means where the husband has made the gift of his house in the name of his wife, or wife has gifted her house to the husband, and subsequently either the spouse, husband or wife is wishing to withdraw, this is not possible. In this case, revocation as a general rule is not possible. Second case is where the donor and donee are related to one another within the prohibited degree by consanguinity. Means where the gift is made by the brother to the sister because they are having the consanguine relation with each other, blood relation with each other. Therefore, in that very case, once the gift has become complete and final, revocation is not possible. According to the law, revocation is not possible. Where the donor or the donee dies, means donor made the gift of a particular item to the donee, and delivery of the possession has also been made by the donor to the donee, and thereafter the donor or donee dies, revocation will not be possible. Where the thing gifted is destroyed or lost. For example, X made the gift of rupees 500 note to the B. Everything was completed. B became the donee of the 500 note, but subsequently he has lost or spent the 500 note, and thereafter the donor A comes and he is claiming the property back. This is not possible. Where the thing given is destroyed means the subject matter of the gift has already been destroyed or has destroyed. In that very case also revocation is not possible. Where the thing has given has passed out of the donee's, say for example, if the where the thing given has been increased in value, also revocation is not possible. Where the thing given is so changed that it cannot be identified, then in that very case also the gift cannot be revoked. Where the donor has received a return of the gift, a rule will not be applicable and donee cannot revoke the gift. Where the gift is of religious or spiritual nature, for this, in this case the gift amount to sadaqah, and this is possible. Under Shia law, the Shia law differs from the Hanafi law in following terms. A gift to any blood relation, whether within the prohibited degree or not, is irrevocable, and delivery of the possession. So, here Shia law is entirely different. A gift by husband to his wife or by husband is, according to the better opinion, irrevocable. But in some other cases, the gift is not revocable.